If you live in a state that doesn't have much leverage because there isn't much dispute resolution, there is a lot of talk right now about applying something called a fee shift to the code. I've got Remington Huggins here of the Huggins Law Firm that's going to help us describe what a fee shift is and why it's really important, especially for the little claims.
That's exactly right. And it matters what jurisdiction you're actually in for the actual definition of exactly what a fee shift is. But let's talk on just the foundation of what we're talking about on a broad spectrum of fee shifting, right? So long story short, when a plaintiff, or in typically our situations, a policyholder files a lawsuit against an insurance carrier, I'm going to use just Florida as an example, okay? File a lawsuit against an insurance carrier. If it comes out at the end, at trial, at court, whether it's a bench trial or jury trial, that the actual policyholder should be awarded X amount of money for their actual breach of contract against that insurance carrier, the fee shifts from the actual policyholder of retaining that attorney and incurred cost to the insurance company to make those payments to the actual policyholder.
So fee shift is when whoever owes that fee changes hands. So if the carrier is acting inappropriately, in the state of Florida, the fee shift exists through litigation. If any additional funds are awarded after a suit is filed, then the fee shift happens at that point, and the attorney's fees would then be due by the carrier.
That is correct. And in Florida, we call it the prevailing fee statute. If the policyholder prevails on $1 more than what that insurance carrier paid out on the claim, that's when the fees shift to that insurance carrier to have the burden of paying the policyholder's attorney's fees.
If there isn't a suit involved, can that fee shift still apply in Florida?
That's a great question. And on cases in Florida, because I do practice in Georgia as well as Florida, I'm licensed in both states. When I do have a case and it's pre-litigation, prior to me filing a lawsuit, I always ask for my attorney's fees from the insurance carrier once I get involved. Some absolutely say not, and then a lot of times they pay it. And I would be honest with you, the majority of the time, they will throw some compensation towards the attorney actually getting paid, even pre-lit in Florida. Because they know the consequences at the end of the road. If they don't pay it now, they're going to end up paying it later, and they're actually going to pay more later on down the road.
That's leverage.
Absolutely it is.
So because a fee shift exists in Florida in some manner, the policyholder or a public adjuster, anybody involved on the insured's side, has much more leverage in dealing with the insurance carrier.
Absolutely. It's night and day practicing in Georgia compared to Florida and some other states as well. I don't want to narrow our conversation just to Georgia and Florida, but yes, absolutely it is night and day when it comes to the two different jurisdictions. No doubt.
Any state that has any kind of a fee shift that is currently codified, you could expect that you would have an easier time working on claims in that state.
Absolutely.
We'll give you an example. This is what it's like to work in a state without a fee shift.
Matthew, no candy. Matthew,
I won it!
No candy.
But I won it!
Matthew, no candy.
It's so good!
No more candy, Matthew. There's nothing I can do.
I want more!
He's just not going to listen to me.
Give
no
me more
candy, Matthew. Nothing changes. The attitude of this child does not change, nor does he care. More importantly, nor does he care what I have to say.
I want more. I'm still chewing. The things I do for Hollywood. In a state where there is a fee shift, it might be a little bit different.
It might be. Matthew, please do not eat that candy.
Please?
Matthew, don't eat that candy.
But
Matthew, if you take one more bite of that candy, you're going to be in timeout for 2 hours. No iPhone, no iPad, no nothing.
Fine.
See, he listened. He listened to this scenario. And in the insurance world, timeout means hitting the insurance company's pocket. They don't like timeout.
That's right. It's like they like money or something. It's really strange. They're
is.
for-profit companies. You guys just noticed he pocketed that, right? That was theft by conversion. So if you live in a state that doesn't have any kind of a fee shift and you are having a bad time with the carrier, getting an attorney involved isn't always what's best for the insured. And this is the real crux of the situation. If you have a small claim, things don't always work out. Let's do some math.
Let's do some math. And I want to give you a real life example of in a state where there isn't a fee shifting statute, or if there's bad faith laws that are very rarely actually entertained by a court, and actually a court awards or a jury awards these bad faith damages to a actual policyholder against the insurance company. This is a true life example of what happens. Let's say it's a run-of-the-mill $20,000 residential roof claim. And by the way, my handwriting's a little so bear with me here.
He's a man. So this is a simple roof claim in a state with some fairly large residential roofs, apparently.
That's exactly right. $20,000 roof claim, okay? What is this policyholder going to net at the end of the road if they decide to hire a public adjuster, hire an attorney, and take it all the way to a jury? Let's just take a quick little, like you said, let's put the marker to the board. Let's see the math on this. Let's say the public adjuster has a 15% fee. So 15%. That's $3,000 out of the insurance carrier, out of the actual policyholder's pocket. They have to hire an attorney. An attorney, reasonable fee here, guys. Let's just say it's 30%. That's typical for a contingency fee across the board in the entire nation.
But you charge like 70%, right?
75 sometimes.
It's more than reasonable.
There's $6,000 out of the actual policyholder's pocket. Right now, they're almost at only 50% of their claim. We're talking right off the gate, that's $9,000 that is out of their pocket for hiring a public adjuster and hiring a attorney. Now, let's say they actually have to go to court and do the steps through discovery and litigation.
This is before they're going to court. They're $9,000 in.
They're $9,000 in. They're 50% of their actual covered peril before they even step into a courtroom.
Even if they skip the public adjuster portion of this, they're already more than 25% of the loss out.
That's exactly right.
In fact, they're exactly 30% of the loss out.
That is exactly right too.
I know how to do math.
That is exactly right. Let's file that lawsuit. There's $500.
It costs $500 just to file a lawsuit?
File a lawsuit and serve it, $500 give or take.
Roughly.
Yep, exactly.
All right.
Guess what? Let's just take two depositions. Let's take the desk adjusters and let's take the independent adjuster who came out to the actual property itself. It's roughly going to be $1,500 a deposition.
How many depositions do you normally do on a claim?
It matters what the size of the claim is. I mean, really, everything is a cost-benefit analysis on the actual claim itself. There's been situations where I've had over $15,000 in deposition fees in cases.
Really?
No doubt. So it matters about the size of the claim. I mean, it's...
You might make that decision based on how much money you're playing with anyway.
Yeah, and you got to talk to the client. Well, hey, do you want me to take this deposition? But by the way, this is going to be another $1,500 out of your pocket. Well, no, don't do it if you don't have to. Do I want to take a deposition on every single adjuster that's stepped on that property, or a desk adjuster that's reviewed the file? Absolutely. But sometimes I don't have those tools to do so.
Do you need to have a deposition to win a case?
You don't need to have a deposition to win the case, but you are at a disadvantage if you step into a courtroom without knowing what that person's going to say prior to stepping in the courtroom.
So the deposition gives you an idea of what you're likely to face inside the courtroom.
That's exactly right. And it also provides you the information on what questions to ask when you're in that courtroom. Wow, he's really weak here, especially with experts, engineers, things like that. It's 100% strategy. There will not be a case where, I've never seen it before, where there is a policyholder taking an insurance carrier to court in front of a jury, and the insurance carrier did not depose that insured. I've never ever seen that. Now, again, there's instances where that's occurred, of course, but it's very rare.
So 2 depositions is a good rule of thumb. That's roughly what you would probably have for an average claim.
I'm just for a $20,000 claim, you need to depose that IA, you need to depose that desk adjuster, and honestly, I don't even want to go down the road and avenue of deposing an engineer. We're talking about $1,500 for that transcript, plus the hours that engineer put into the deposition, that's taken away too. I've deposed an engineer that's cost almost over $7,000 before.
Who pays those costs? Whoever orders that deposition?
Yes, so when it comes to the engineer,
Any of them, I guess.
if I ask an engineer to come and take a deposition and it's an insurance carrier's engineer, it's my responsibility to compensate that engineer for their time. And it's vice versa. Across the board, federal rules where if somebody wants to depose the policyholder's engineer, that insurance carrier is responsible for paying the reasonable cost as an expert to provide testimony. But when it comes to actual IAs and desk adjusters, you still have to pay for that transcript. And that's gonna, like I said, give or take $1,500. So that's where we're at. Just on 2 depots. And this is not an expert deposition, okay? I'm giving you guys the best case scenario.
All right.
Next, after depositions in a lawsuit, we're actually gonna have to pay for testimony. So let's say this, and I say testimony as in your weapons. Who is that? That's your engineer. If an insurance carrier has an engineer and you're going to trial, I always have an engineer. You can't go to a gunfight with a knife. You gotta go gun to gun.
So you're bringing in your own expert to prove the loss, just like they've used their expert to disprove the loss.
That's exactly right. And you'll see any type of reviews about a jury and actually having testimony from a licensed engineer versus not having it, they put so much more weight on somebody having PE behind their name than just a regular contractor or an adjuster. They really do.
What if the carrier didn't get their own engineer involved? Would you still want to get one for a simple roof case?
Great question. And the answer to that is I would want more facts, but here's the case. If we are going to court to discuss causation and was this roof damaged or not from a hailstorm, I want an engineer. If we're going to court because we're disputing over the cost to replace that roof, I don't need an engineer. So that broadly, those are the 2 examples where I wouldn't need an engineer versus I want an engineer.
Well, this one, they've denied the entire claim, so you need an engineer.
I want an engineer. If the insurance carrier has an engineer, you got to have an engineer.
How much does it cost?
$1,500 to $2,000. Let's just say $2,000.
You ever wonder why train drivers are called engineers? So $2,000 for an engineer. How much does all this add up to?
So let's just add this up. And again, this is best case scenario, folks.
14.5 out of this.
Is that math correct? I think it is. Catch me if I'm wrong.
14.5? Yeah, that's it.
$5,500 that policyholder is going to get in a state where they're not receiving bad faith and there is no fee shift. Ladies and gentlemen, this is real life. This is the reason why sometimes possibly Matt as a public adjuster cannot take a claim at the end of the day. And this is a reason why I can't take claims at the end of the day. Because if we step into litigation, I am telling my client, I don't know when this is going to end. And this is the truth, because the ball is in that insurance carrier's court. It could take 18 months. It could take 2 months. But if I drag my client, I cannot go to sleep at night if I have to drag my client through 18 months of litigation. They sit through many depositions. They're out of pocket this amount, and they net this amount. I can't sit at night and go to sleep without actually explaining this to potential clients before they sign any type of agreement. And again, guys, this is best case scenario.
I mean, in a state without any kind of a fee shift where you just don't have much leverage, this is why you don't have leverage. The carrier knows this. They've done this math every day. And they know that it is not in the best interest to file suit for the policyholders. So the policyholder is less likely to file suit. And that means that the carrier is less likely to have their hand slapped or to be sent to timeout.
That's exactly right. That's a good way to circle it back around. Not to mention other elements that are only going to reduce this amount of $5,500. Let's say there's a comparative estimate. Let's say the actual insurance carrier has their own contractor or consultant to get up on that stand and say, this $20,000 roof actually costs $12,000. What does that do? I mean, we're talking about...
That zeroes you out. You're negative money.
We're talking about not making any money after 18 months of a gauntlet of litigation. So there's one element that comes into play, and they will, if they're a good attorney, and I don't know if I want to say this, they will get a comparative, and they will show they can get that work done for less. Number two, what if the jury actually applies a deductible to their actual loss? Let's say that the actual policyholder has a 2% hurricane deductible. This is completely wiped away. It's completely gone. And also, I want to be realistic with everybody. This 30%, as an attorney, goes to 40% when you go to trial. And any attorney, that's standard across the board in America, that you go to trial, you go to 40%. Now, everybody has their different structures, but I'm just saying as a standard principle, this actually goes to 40% when you step into that courtroom and get in front of a jury. Now, those are different variables that only do one thing, and that's reduce the net amount that policyholder is going to put in their pocket. They can't replace their roof.
They can't. There's no way to.
And
they're going to get dropped if they don't.
Get dropped if they don't. And here's another element that is just realistic and it's real life for states who don't have a fee shifting formula, is that you do hire an engineer. You hire that engineer to inspect the roof and to write a report. This $2,000 does not take into consideration getting that engineer to fly in or to drive to the courtroom and to testify for a day. That's a whole nother at least $3,000 for them to come and testify. I mean, these are all these elements that a lot of people don't understand. They don't see. I've lived and learned it. When I first started this, I swear, I was cranking out $15,000 and $20,000 roof claims like it was like all the time.
Sending them to you. I'm sorry. I'm so sorry.
I've lived and breathed it, but I feel like you have to actually experience these situations for it to be a real life, and this is fact. This is zero exaggeration. In fact, going through those 4 to 5 different elements that would actually alter this $5,500 is fact and true. This is the best case scenario.
If there's a fee shift, and in some states that have them, if any increase occurs, if they do end up with a $5,500 settlement and it was started at 0 or even started at $5,599.99.1, that 1 penny or portion of a penny increases it, then at least the attorney's fees would get paid. Do the rest of these costs get paid as well?
Again, it matters what jurisdiction you're in. But typically on a fee shift, it will be attorney's fees plus incurred costs to defend your actual breach of contract.
If the insured hired the public adjuster prior to the attorney, in a state where the fee shift occurs after suit, could the public adjuster fees get paid?
That is a jurisdiction-specific question. I'm just using the state of Florida because I'm barred there. So if you go through a breach of contract actual suit itself, you go in front of a jury and you win. Prevailing fee statute comes in, boom, automatically this 30% and these fees that the actual policy holder incurred are paid. Then if it's set up correctly and there's a civil remedy notice that's filed, you can then file a lawsuit against that insurance carrier for bad faith. That's when the PA fee can get paid.
So in the state of Florida, there has to be a jury trial even for the attorney's fees that get paid.
Well, technically, that's when they're supposed to, but when an insurance carrier and the smart defense counsel sees that, look, we don't want to go in front of a jury, if they're going to pay one more dollar, then all these fees are paid for, and it's only going to be increased for the amount of time that this plaintiff's attorney is involved. That's when they try to settle them as quickly as possible.
So more likely than not, they're going to settle outside of court. They'll still give you the attorney's fees and possibly your costs. The public adjuster fee is probably still not going to get paid. So what would be the benefit of getting a public adjuster involved in a state where there is a fee shift like this?
Well, the public adjuster sets it up. If it's a good public adjuster, like you, Matt, of course, they set it up perfectly so this attorney can take the football, so to speak, and run it to the end zone using all the documentation that they provided. Now, again, it would go back to the contract between the public adjuster and that policyholder. We get the 15% of the gross proceeds, whether it go to an attorney or not. So at the end of the day, potentially that public adjuster, let's say we do go to trial and we win $20,000, you should get your share of that actual outcome.
That makes sense. So in a case where the public adjuster isn't hired prior to it going to you, there's a lot more work that you have to do on your end because that public adjuster might have set it up to where you could eliminate a lot of the time and effort and possibly avoid even going to a jury trial.
Absolutely, 100%.
So you like getting PAs involved?
I love getting PAs involved.
That was the right answer. I was going to cut you off if you said something different.
But guys, it's really, it makes it real when you actually see these steps and these layers that a policyholder has to incur in the actual fight they have to put up, whether it be money, hiring people, taking time from their job to sit for depositions, and they're still rolling the dice, not knowing if they're actually going to get compensated and they're going to win at trial, because you never know what's going to happen at trial. So it's a lot of burden on that policyholder.
The fee shift that we're talking about, we're trying to apply to insurance claims, but in reality, a fee shift already exists in every state, in every single one. But they've taken that away from insurance claims for some reason. We're just asking them to apply the same laws that everything else gets to insurance claims. Is that such a big deal? I don't think so.
I don't think so either. I think it should apply to the insurance carriers just like any other contract in any other jurisdiction. Really do. They're protected, and it is what it is. It's reality we face.
If they mess up, they should have consequences.
They should go to timeout.
Yes, they should. I want candy. Hey, if you're getting a lot out of these videos, we'd appreciate it if you hit that subscribe button and that bell icon so you get notifications whenever a new video comes out, and share this with as many people as you can. We want to make sure that policyholders are being taken care of a little bit better. We need to educate everyone in this industry on how to deal with the insurance carriers. And if any of these situations has happened to you, make sure to tell us about it in the comments below. Let's have a discussion. Like and share.